Welcome to Canadian Justice. I'm Christine Van Gyn, and today we are discussing a legal challenge to Canada's prohibitions on sex work and a recent Ontario Superior Court decision in that case. The legal status of sex work is no longer ambiguous. The purchase of sex is prohibited. Sex work is not legal, but sellers of their own sexual services are immune from prosecution. Parliament also prohibited other activities around sex work, such as procuring, advertising, stopping traffic, and communicating for the purposes of sex work near a school, a daycare center, or playground. Although advertising is prohibited, sex workers are immune from prosecution for advertising their own sexual services. Parliament also created an offense of receiving a material benefit from sex work, but also created exceptions for non-exploitive third-party relationships. A group of sex workers challenged these prohibitions, along with a former escort manager and an organization called the Canadian Alliance for Sex Work Law Reform. They argued that the offenses violate the right to life, liberty, and security, the right to freedom of expression and association, and the right to equality. However, the Ontario court dismissed their challenge. Here today to discuss this is Jenn Clamen, National Coordinator for that organization, the Canadian Alliance for Sex Work Law Reform. Jenn, thanks so much for joining me today. Let's start with your initial reaction to the ruling from the Ontario Superior Court dismissing the case. What's your reaction there?
Obviously, we're very disappointed and gutted by the reaction. Both the individual applicants and our alliance of 25, 26 sex worker rights groups. It's a huge dismissal, not just of the case, but of the realities and the evidence brought forward by the thousands of sex workers that make up our member groups. The Crown outright sort of dismissed so much of the evidence and really didn't engage with much of the facts. And it quite literally reproduced the Crown's arguments in its decision. So obviously we're disappointed, but perhaps not so surprised.
So can you tell me, why did you and your organization, along with those individual applicants, why did you bring the case? Why were the issues of, advertising, communicating, traffic stopping, and the school issue, and the school issue I'm interested in, why were these an issue for you guys?
Sure. I mean, it wasn't the school issue in particular, and we can get into that. So the case was brought forward by 26 groups of sex workers across the country that represent thousands of sex workers in the industry and 5 individual sex workers. It was really important that sex workers across the country were able to make visible the harms that they experience when sex work is made illegal. And there was when these laws were implemented, there was no ambiguity about that. Sex work was made illegal. And there's harm that comes with that to the people working in the industry, the harms of criminalization. And what we attempted to do with this case was to really center the experiences of the sex workers who are most marginalized in the industry, those who are living in the most poverty, those who are living with the most surveillance and racial and social profiling from police. So that's Indigenous sex workers, Black sex workers, migrant sex workers, trans sex workers, to really center those experiences to demonstrate how criminalizing any part of sex work has harm for sex workers, because the whole intention or supposed intention of this Canadian society is to protect the rights of the people within it, and those rights aren't being protected under the current legal regime.
So let's center their stories right now. Why don't you tell me some of the stories of these women and how this law was impacting them?
Sure. I mean, I could tell you broadly what the impact of criminalization is. If you can imagine that when any part of sex work is criminalized, it means that sex workers are entrenched in criminal activity, whether they are being arrested or not. There are harms of criminalization that come to people. It forces sex workers into isolation without a lack of supports, both community and institutional supports. It exposes sex workers to different risks of eviction, child apprehension. Increased surveillance has huge harms on sex workers, particularly for those sex workers who are already over-surveilled and underprotected in public space and in private space. In the context of the sex work exchange, when you've criminalized the purchase in every context, and I'm only talking about the purchase here, you're preventing meaningful communication between sex workers and clients. Establishing consent is really important to do in any sexual interaction. And these laws actually prevent sex workers from establishing consent because clients are not motivated to share information or even to share their needs of what it is they need in that moment or that interaction of that service. It also means that sex workers who are additionally surveilled because of, many people in the sex industry are surveilled anyways with other laws, and sex work laws are just an additional tool for particular
We've got to go to
communities.
break, but when we come back, we'll continue this conversation.
Yep.